Well, good afternoon, everybody. The breaking news today, as we just heard about, maybe some of you have seen it already, Karen Reed has filed a civil rights lawsuit against Proctor and the gang. So we've got to discuss it. We've got to break it down. And I figured I'm going to try my hardest today to bring you a very special guest. And this is the guest who a lot of people have been asking for all the time. And we've used to have him on when the Karen Reed trial was actually going on, but he's just so busy and it's hard to nail him down to get him to come. And I told him, look, this is very important. I'm your brother after all, and you've been blowing me off all this time. It's time for you to join back with Brother Counsel to break down this complaint, because this is right in your wheelhouse. We've actually been talking about this idea with him before about Karen Reed's possible civil rights lawsuit. Now we're actually seeing it play out. So you kind of brought up the idea in the first place. So you got to come now and talk to the people about it. So bouncing around different court appearances today, I know that he was, but we actually were able to nail him down for some amount of time to break down some of the counts of this complaint. Now it's a 46-page complaint, and we're not going to be going through all the complaint. Maybe we'll do that in a different video, but I want to concentrate specifically on the counts that are alleged in this complaint. So without any further ado, let's bring on national trial lawyer Solomon Radner. Solomon.
As always, Martin, it's great to be here. Brother Counsel is without question the greatest law tuber out there. So it's always a pleasure for me to be on.
Well, yeah, I appreciate that. And I know that comes as an unbiased opinion of yours. But my first question to you really is that I know you were bouncing around a bunch of different court appearances today, but I do know that there was no court appearance Sunday night when we were supposed to be on the ice. And you were noticeably absent. So I'd like to hear your explanation. And I think everybody watching wants to hear your explanation why you didn't join our team there out on the ice.
You don't remember where I was, do you?
I don't.
My mother-in-law was getting married Sunday night in New York. My father-in-law passed away 12 years ago. And my mother-in-law got married this past Sunday night in New York. So my apologies if I couldn't make it back to Detroit in time to play.
Oh, darn. That's a good excuse. All right. Well, okay. We're going to have to let you off for that. But everyone in the locker room was discussing where's Solomon. So you were missed. Yeah. But anyway, I know, Solomon, that you're very busy, and I appreciate, again, you joining us, Brother Counsel. Sometimes I feel like I should step away from the channel to help you out in the civil rights department over there. I know it's growing, and there's a lot of work to be done, and you've kind of floated the idea across my desk a few different times. But what do you think? Think I should step away from the channel and join your practice?
Well, as much as I can use the help, and we do actually work on cases together quite often. So I know you don't do a whole lot in civil rights, but we still do work on cases together. So I don't want your viewers to think that we don't. But sure, if you're willing to step away, there's plenty of, unfortunately, there's enough civil rights violations to keep both of us quite busy.
Yeah, unfortunately. All right, well, let's get into the Karen Reed stuff. Before we actually talk about this complaint, I don't know if you're aware of this. I am, obviously, because I'm in this world. But there was a report yesterday. We haven't seen any filings about this, but there was a report yesterday about a possible defamation lawsuit filed on behalf of, and someone correct me if I'm wrong, I believe it was on behalf of the McCabe's, the Alberts, and Brian Higgins against Karen Reed. So there's some reporting that this may be coming down the tubes, a complaint for defamation. What's your initial reactions to that?
My knee-jerk reaction to that is, I guess, sometimes having a strong offense is your best defense, and it appears that perhaps they know they're in a bit of trouble now that Karen Reed was found not guilty of all the murder charges and all the charges that involved her allegedly hitting John O'Keefe. They certainly knew that this lawsuit was coming. They certainly have been figuring out and discussing how best to respond to it and how best to deal with it. And apparently they came up with this idea that if they file a lawsuit against her for defamation and slander, then that would be a good defense to the lawsuit. At least that's kind of what jumps out at me about this. I think that if they actually do go through with it and file that lawsuit, it not only will almost certainly lose, but I think it will demonstrate a major lack of self-awareness on their part. Because looking around at who believes what in this particular case, it appears from what I've seen that the overwhelming majority of people do not believe that Karen Read is guilty. I certainly don't think that she is. I don't think there's any evidence that she is. The only evidence that ever plausibly could have existed pointing to her guilt makes no sense. I think the defense proved her innocence, which means that there's a lot of unanswered questions into the so-called investigation that took place. You can't have a good faith investigation and this not guilty verdict. It's one or the other. So if they want to respond to a punch with a punch, I guess that's their prerogative and they can try that. I don't see a lawsuit like that going anywhere. And frankly, I think this lawsuit that Karen Read filed, I know I'm kind of jumping the gun here, but it's excellent. It's well written. It's well pled. And the attorneys working on it obviously have a very solid handle on civil rights litigation.
Okay, so in terms of the defamation lawsuit, you don't see much merit in that, and I would echo that. I put out a little tweet about that yesterday, and the thing with defamation lawsuits is, number one, is that anything that you say in court defending yourself cannot be used against you for a defamation lawsuit, right?
Right. If it's in court, it can't be used. If it's, well, generally speaking, if it's in court, it can't be used. But there's a lot of statements here that were not just made in court; they were made all over the place.
I agree. I agree with that. And one of the things that the attorneys that represent her, I think, in the article alluded to is that let's not forget that truth is an absolute defense to defamation, and one of the first elements is that the statement has to be false. So that would mean that they'd have to completely relitigate this case, right? And show that Karen Read, when she said a comment, if she did, by the way, and first you have to find a statement that she said, well, that she stated as a fact and not her opinion. So that's number one. And I've explained this on the channel before, that even if you say, I'm going to tell you something as a fact and it's an opinion, it's still going to be considered an opinion. So, they first have to find that statement that she said where she implicated one of the other people that said, that they're in on the cover up or whatever it is. Then they have to prove that it was false. And also there's a negligent component here where that she had to have a good faith belief that it wasn't true. So even if they're able to prove that it wasn't true, but there's so many questions, as you said, that she can say, well, my honest belief was that it was true. So it's everything that I see about this defamation lawsuit. Like I'm echoing your sentiment here that it seems to me like a gigantic waste of time.
Right, and I think that the most important thing that we have to look at here is the fact that they have to prove that the statement was false. They have to be able to prove that. Truth is an absolute defense. That's true, but separate from that is they have to prove it's false. If she doesn't prove that it's a true statement, she could still win the case if they don't prove that it's a false statement. They have to prove that it was a false statement. And I don't see how they could possibly do that. Like you said, are there words that can be twisted? Maybe. Are there statements that other people made, such as her attorneys, that can be used against her? Possibly. We saw that in the Johnny Depp case, by the way. So that's a possibility. But I don't see defamation here. If somebody does something, or you believe that somebody does something wrong, and you call them out and say that they did it, that's not defamation. Saying something bad about somebody is not defamation unless it's not true, and that's going to be a very difficult thing for these folks to prove if they try to sue Karen Read for that.
Yeah, I'm not sure if there's enough blue paint in the entire state of Massachusetts to prove that that it was false. Okay, so anyway, let's move on to the actual complaint that Karen Read filed. Now, by the way, I do want to mention also, because I know some people are talking about this. This lawsuit was not just filed against. I mean, this reporting of a potential lawsuit was not just naming Karen Reed as a defendant, but also Turtle Boy. And, and like you said, even though he's much more open about his beliefs and opinions, the still same uphill battle applies with him, I believe, as well. All right. So let's pull up the complaint. Before I actually get to the counts, I want to show you some part of this complaint that I love, because you know my style of writing and you know what I like. I know your style of writing. I know what you like. So there's a lot in this complaint we're not going to go through, but this part I just want to highlight for everybody on this show. Again, maybe we'll go through the entire complaint on a different video, not when Solomon's here, because I can't waste his time. But just take a look at this. On June 18th, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory in part because the overwhelming physical, scientific, and medical evidence established that Ms. Reed's vehicle did not strike Mr. O'Keefe, and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Ms. Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Ms. Reed. Now that just sets up the next one, the next paragraph. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as Colonel, the State Police has and will continue to improve in these regards." In an interview with the Boston Herald, Noble acknowledged the systematic nature of MSP's conduct in Ms. Reed's case. "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor." These hollow words do nothing to right the devastating wrongs that have been visited on Ms. Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it.
Unbelievable writing. Really unbelievable writing. Something that people forget when lawyers file lawsuits is that we're telling stories. We're not just laying out facts. We're telling a story. And whoever drafted this, whichever attorneys actually drafted this, and I know that when it comes to drafting lawsuits, let's just clear the air about this. There's always going to be a number of attorneys that sign the pleading. There's going to be even more attorneys that worked on that pleading. And very often there's non-attorneys that work on it as well. A complaint that's 46 pages long with this much facts was almost certainly worked on by probably at least a dozen people. Whoever did the writing is unbelievable. This is exceptionally good writing. It's very good storytelling, and it really kind of gets to the DNA of what's wrong with this case. Just in these 2 paragraphs, you see that.
Yeah, and those are my 2 favorite paragraphs. I mean, they obviously they go through the entire story, which is well written, like you said, but like that, those specific paragraphs are just my favorite part, because it just slams it in the gut. It's like, it's such some great snark, some great, it's just great writing.
Well, hang on. Let me tell you 2 more things about this. If you go back up to paragraph 14, I can tell you that any attorney is going to have an absolute blast cross-examining Jeffrey Noble when it comes time to discovery, because you can go through this entire statement and ask for details. What events of the last 3 years? How have they challenged your department? Why did it take this to thoroughly review your actions? If not for this case, would you have thoroughly reviewed your actions? Was there appropriate oversight beforehand? Was there accountability beforehand? What has to be improved in these regards? Why do your eyes have to be open to the culture issue? What concerns do you have as it relates to Trooper Proctor? There's a whole line of questioning that will exist in Noble's deposition because of these statements that you make. And I'll tell you right now, you know that I've had a lot of cases in the news, and it's always very concerning. It's something that every lawyer thinks about. What do I want to tell the news, and what do I want to let my client tell the news? And in a case like this, if I were the attorney for the defendants in this lawsuit, I would say everybody just stop talking. Just nobody say anything. Any statement that has to be made, have it go through your attorney, because you're not going to do yourself any favors. And just one more thing, back up to paragraph 13. I want to point something out here that I saw that kind of jumped out at me. And that is, if you see over here where it says On June 18th, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory. That's an absolute fact, 100%. Then they go on to say, in part, because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe. Now, this is excellent writing, and I love the way they did this, and I would have done the same thing by stating this as a fact, because you definitely have a good faith basis to make this allegation. I want to see what the defense is going to respond to this. What are they going to say? Are they going to say, yes, that's what it was? Are they going to agree in part and deny in part? Because the reality is, we don't know why the jury said not guilty. It could have been any host of reasons. It doesn't necessarily mean that there was overwhelming physical, scientific, and medical evidence that established that Miss Reed's vehicle did not strike Mr. O'Keefe. We don't know that that's what the jury believed, and we don't know if that played a role. Something that I've learned from talking to juries after verdicts is you never know what they're thinking. It's really hard to guess why a jury came out with the verdict that they came out with. But I still like the way they did this. I like the way they included this in a fact, because every single paragraph that's alleged in the complaint, I know you know this, but in case your viewers don't know this, every single paragraph has to have a corresponding paragraph either admitting or denying the allegations in this paragraph. So it'd be really interesting to see what the defendants say about paragraph 13. Are they going to admit this? Are they going to deny this? Are they going to admit and deny in part? Okay.
Right.
You were saying.
Yeah, I mean, that's a good point. Yeah, I imagine, like what you said, they're probably going to have to admit in part and deny in part, admit that the verdict was not guilty and then deny everything else. But here, okay, so now let's talk about these counts, because you are very familiar, obviously, with these counts. Okay, so before we even actually jump into this one, you see there's a little footnote here, and I always tell my viewers about how I love footnotes. So there's a little 4 there by counts, and we go down here. I don't know if you can read it. It says in the footnote here, after making presentment pursuant to GL 258, Section 4, Ms. Reed will add counts against MSP for negligent training, supervision, and retention of MSP troopers, including Proctor, Buchanan, and Tully, and B, the town of Canton for negligent oversight of the investigation into Mr. O'Keefe's death and of its own officers and facilities. So there are certain counts that they are not including at this point.
Right. So the way this works is when you file a claim like this, every claim that you file can be put to one of 2 buckets: federal claims and state claims. A federal claim is a claim that's based on federal law or the Constitution or the Bill of Rights, the amendments, your constitutional rights. The state law claims are going to be based on state law. All right. And they're completely different, and they can be filed in different lawsuits. And I've done it both ways. I have filed one lawsuit with both state and federal claims, and I filed them 2 separate lawsuits, one with federal claims, one with state claims. There's merit to doing both. Generally speaking, I like to combine the 2 if at all possible. If you can do it if you can do them both properly, and obviously this is a situation where they can. So they included them all together. The problem is that in order to include all claims against all defendants under state law and under federal law, there's going to be very specific requirements under state law that sometimes don't apply to federal law. Federal law, you can almost always file a lawsuit, especially if it's a 1983 claim, without any sort of presentment or notice. Something happens to you, you can file a lawsuit. You can file a First Amendment lawsuit, a Fourth Amendment lawsuit, an Eighth Amendment lawsuit, a due process lawsuit under the 14th Amendment. There's all kinds of 1983 lawsuits that you can file without notifying anybody that you're going to file them. A lot of lawyers do, but a lot of lawyers don't. I virtually never do, unless I'm required to under federal law, which is very rare. Under state law, and I know that Michigan has this, I know that there's a lot of states that have something similar. If you want to sue a government entity under state law, under a state law theory, you have to give them notice of some sort within a certain amount of time. And then they get a certain amount of time to respond to you before you're allowed to file suit. So obviously they made their presentment under this GL statute, but they did not get a response yet, or not enough time has elapsed in order for them to be able to include it as a lawsuit. What they're anticipating is that despite them making this presentment, they're not ultimately going to settle the claims that are being made in the presentment, and that's going to allow them an opportunity to file a lawsuit. Rather than filing a brand new lawsuit, they're letting the court and the defendants know right now, we are going to be amending once the time passes and once we're able to, and then we're going to include these counts as well. And obviously they're going to be suing both the MSP and the town of Canton for their negligent oversight, essentially.
Yeah, and I took a look at that statute also, and exactly what you said. You have to present these claims before you file suit, and a certain amount of time has to pass. And also something that obviously sticks out to me, and it's just something in terms of strategy that I was thinking about. We know that a state cannot be sued in federal court, right? That's the 11th Amendment, right?
Right.
So they're making a claim here against the state. This is MSP, which is really, right, you're suing the state, right? So they want to bring this into the state case. And part of me is thinking, and from my understanding of what this statute is that this is not the strongest claim that they have. I know it looks pretty bad from the way that they say it, because that's what they're going to make it look. But if you actually look at the statute, this claim against the Massachusetts State Police for negligent suit training supervision, there is a different part of that. But just looking at the statute itself, I'm not so convinced that this is the strongest claim that they have, and maybe even perhaps be dismissed. And that's not, again, it's not the strongest claim. They have all these other civil rights claims, which we're going to go through in a minute. But this could be a strategy that they want to keep this case in state court, which is why they're adding this claim against the MSP. Because if it's in state court, the only way to get into federal court is if the defendants remove it and then they waive their immunity. Isn't that right?
Yes, that's correct. And it could be that's why they're doing that. But yes, under the 11th Amendment, you cannot sue a state agency in federal court. This claim was filed in state court. What usually happens, and what I would bet will happen in this case, is they're going to remove this to federal court. And interestingly, and again,
if this state claim is in there, would they remove it? Because if they remove it, then they're going to have to waive immunity.
Right. They're waiving that immunity, but they're going to have to litigate this anyway. So from their perspective, the ultimate decision is not going to come down to this one claim. It's going to come down to, do we want to litigate this in state court or in federal court? That's tough. That's real tough. I mean, given the amount of press that this case has already gotten and will continue to get, obviously the lawyers for the defense and obviously the lawyers for the plaintiffs as well, part of their decision is going to be, where do we file this, state court or federal court, and what do we do with it? Obviously, they filed this in state court. They could have filed this in federal court. I filed virtually all of my civil rights lawsuits in federal court. But if their goal is to bring in this additional claim, then that explains why they filed it in state court. And then this way, if it gets removed, at least they're on notice that they plan on amending this. And how this actually plays out, of course, is going to be a very good watch. But one more thing that I wanted to add is that whether you file this in state court or in federal court, the claims that are going to be litigated are going to be the same claims that are litigated. It's the same underlying facts, but in federal court, you have a much higher burden of proof. You have to prove recklessly, intentionally, maliciously. You have to prove those things in federal court for federal claims. Whereas for the state claims, based on at least what I see here, negligence is enough. So if you can win the case with negligence, obviously you're going to want that claim in, even if, as you said, it's not the strongest claim out there. The damages are astronomical. She faced a murder charge for 3 years. And it was totally bogus from day one, from minute one, from Hasselong to die in the cold. It's been a completely bogus case. And she was forced to every single day wake up and think that she may die in a prison cell for a murder that she did not commit. That is torturous. Absolutely torturous.
Yeah, see now, right. I mean, the damages here obviously are going to be through the roof. What I was thinking here is that what they plan on doing is they file this as an independent lawsuit right now. And what they're going to do is they're going to then move to consolidate this complaint which is filed in a separate court, separate action. And they're going to move to consolidate it with the case, the wrongful death case that Karen Reed was sued by the O'Keefe family and the estate of John O'Keefe, right? So this is what their plan was. They kind of let us know during the last hearing that they're going to file this separate complaint. They're going to have everybody served. Then they're going to move to consolidate into her case where she's defending against a wrongful death that the O'Keefe family filed against her. Now, my thinking, and kind of what you were saying, do they want to be in state court? Do they want to be in federal court? My thinking is that I would think that the Reed team wants to be in state court for the simple reason that, it's an open courtroom. They allow cameras in.
Right.
There can be a lot more publicity for it, and that can be very helpful for them. As opposed to the other side, they perhaps would want to be in federal court. They don't allow cameras in there. We're going to be kind of groping around in the dark, trying to figure out what's going on in there. I mean, we'll be able to see the filings, but we're not going to see that. We're going to be not going to be able to see all these motion hearings and the trial potentially. So I would imagine that the Reed team would prefer to be in state court, and all these other Proctor and all those guys and the MSP, they would prefer to be in federal court where there's a lot less scrutiny on what's going on. And which is why I question about whether this is a great tactic if you want to keep the Reed case that she's defending against herself open to the public as much as possible. Why move to consolidate? If you move to consolidate and then, like you said, they remove it, the entire case goes. The entire case goes to federal court. And therefore, we don't get to see the wrongful deaths case that Karen Reed is defending against, and we don't get to see this case. So that's why I'm trying to wrap my head around the strategy here. But maybe that's why they're trying to add this MSP so that they won't remove it, because then they'll waive immunity, even though, like you said, they're going to be facing it one way or the other. So why not? What do they care? Maybe they'll face it in federal court. But that's just something else. Now, let's get through to these actual counts. Okay, so we got count number 1. Malicious prosecution under the Fourth Amendment against Proctor, Buchanan, and Tully. And again, I don't want to read this throughout it. We kind of know the facts in this case. We know the type of things that Proctor has done. We know Buchanan's involvement, and we know Tully was supervising everything officially. He was somewhat involved also, but he was a supervisor. So what can you tell us about this malicious prosecution claim, the first count in this?
Okay, so malicious prosecution is brought under the Fourth Amendment pursuant to 42 U.S.C. 1983. Pretty much all these federal claims are going to be brought pursuant to 42 U.S.C. 1983. Malicious prosecution, you have to establish that a prosecution was initiated or continued against you, that there was a favorable termination, meaning that you won the case, you were found not guilty, or you get the charges dismissed, and that there was no probable cause to charge you in the first place. And then obviously that there was some sort of malice. That's why it says malicious prosecution. So those are the general elements when it comes to Fourth Amendment malicious prosecution. What's interesting about this case is, and I can assure you, or at least I would guess, that the defendant is going to raise this in their initial 12b6 motion, which is almost always how these lawsuits are responded to, with a motion to dismiss the case. They're going to say that there was not a favorable termination because she was found guilty of one of the crimes. Right? When you're found guilty of one of the crimes, that takes away your right to file a malicious prosecution lawsuit, because generally speaking, so long as there is a conviction, that's not favorable termination. Okay. However, in this case, it's going to be a little bit different because, and we've talked about this before on your channel, and I'm sure some of your viewers might remember this. There's a case called Schiavarini versus City of Napoleon, which is a U.S. Supreme Court case, which says that even if you are found guilty of one of the charges, it is possible, under very specific certain circumstances, that you can still have the without probable cause and favorable termination component satisfied, depending on the facts. The most obvious example of this is, let's say somebody is drunk driving, and there's absolutely no evidence whatsoever that they robbed a bank, but you charge them with drunk driving and robbing a bank. Or, let's take another leap of logic. Somebody is drunk driving and somebody decides to charge that person with murder, even though there's absolutely no evidence whatsoever that a murder took place or that a killing took place, by her at least. Obviously, a killing did take place here. It's possible that a murder took place as well. But it certainly, there's, in my opinion, absolutely no evidence whatsoever that Karen Reed did any of it. So this Schiavarini case would come into play because even though she was found guilty of drunk driving, there's absolutely no basis whatsoever to say that she was found guilty of the murder. And that being the case, you then have to point to specific things that affected her civil liberties and her civil rights because she was prosecuted with these additional charges. Obviously, a 3.5-year long trial, multiple trials, 3.5 year long prosecution ultimately, and all of the restrictions that come with facing a murder charge, and the thought every single day, the torturous thought of possibly spending the rest of her life in prison, all those things are going to weigh in favor of this being favorable termination and without probable cause, even though she was found guilty of the drunk driving charge. And if you want, I can send you the link for this case. It's a very interesting case and a very interesting read.
Yeah, why not? So, okay, yeah. So that's how they can get around this whole, she was convicted of OUI.
Right.
What, just kind of tell a little bit, explain to the audience, what does this mean? Thus, Proctor Buchanan can tell the acting under color of law. Why do they throw that in there?
Under color of law is required under 42 U.S.C. 1983. And if you want, we can pull up the elements. I don't know if you have them pulled up or not, but the elements of 42 U.S.C. 1983 require that somebody is acting under color of state law, meaning that somebody's acting in their capacity as a government worker. If a police officer comes over to you at a baseball game and he's just watching the baseball game, drinking a beer, and he punches you in the face, he's not acting as a police officer. He's just acting as some drunk nut. So you can't sue him for 42 U.S.C. 1983. You could sue him for assault, but you can't sue him for 1983. If, however, he says, "Stop, I'm a cop," and then you put your hands up, and then he knocks you in the face, well, now he's acting under color of state law. He invoked his being a police officer in committing that assault. So that's what under color of state law means. It just means that they're using their authority granted to them by the state to deprive somebody of a constitutional right. I can tell you that this element is almost always either stipulated to, or the judge finds a directed verdict or summary judgment on this element. So this element almost never goes to the jury, because ultimately the question of whether they were acting under color of state law is obvious. If they're doing an investigation, a murder investigation, and testifying as police officers and arresting somebody as police officers, and officer in charge of the case, I don't know who they're going to say was the officer in charge of the case, but I digress.
The lead investigator.
The lead investigator. Obviously, they're acting under color of state law because they're acting in their capacity as police officers. But that's what it means, and that's generally how it plays out in court.
Talk to us about this last thing. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney fees under 42 U.S.C. 1988, costs, interest, and punitive damages. So tell us about that in attorney fees when it comes to civil rights litigation.
So the way it works with civil rights is if you file a 42 U.S.C. 1983 claim and win, and you're the prevailing party, you get to seek attorney fees. The way attorney fees work is actually, and this applies to a whole host of different civil rights violations, 1981, 1982, 1983, 1985, other ones I'm sure that, I can't think of right now. The RLU IPA is one. These are the Civil Rights Act. Pretty much any federal civil rights action that you're going to file. 42 U.S.C. 1988 says that if you're the prevailing party, you get to get attorney fees tacked on. And that means that if you go to trial, let's say you go to trial and you win $100 million, which honestly, in this case, I don't think is outside the realm of reasonable. But let's just say they win $100 million. Most lawyers who do this kind of work do it on what's called contingency, meaning I file the lawsuit, you don't pay me a penny. If I win, I get a percentage of whatever we collect. So that percentage is usually somewhere on a sliding scale between 25 and 45%, depending on the state and depending on whether it's collected before or after filing a lawsuit. There's a lot of things that go into exactly how much the contingency fee is. It's also governed by state law. But that's generally how that will work, is that let's say you get $100 million, you get a percentage of it. You also get to tack on what's called attorney fees, which means let's say you go to trial and you get $1,000. So you go to trial, the jury gets to award however much they feel is appropriate, and they say, here's $1,000. But you spent 5 years working on the case. You're the prevailing party. What you can do now as the prevailing party is ask for what's called lodestar. And lodestar fees, the way that's calculated is what's your reasonable hourly rate and how many hours did you spend on the case? So if you spent 1,000 hours on the case and your reasonable rate is $500 an hour, you get an additional $500,000 irrespective of how much money was collected, assuming you're a prevailing party. Now, if you go to trial and you're asking for millions and millions of dollars and the defense gets up and says, he's only entitled to $10,000 at most, and the jury comes back with $10,000, it's going to be very hard to say that you're a prevailing party entitled to all those fees because they were willing to give you that in the beginning, right? So the amount will sometimes come into play as to whether or not you're considered a prevailing party. But generally speaking, in these kinds of cases, if you get a verdict in your favor, you can seek lodestar fees. Very often, the way these retainer agreements work is the attorney has the discretion to either tack the attorney fees onto the total amount and then get his percentage of everything, or just to take what's awarded by the court. So if let's say you get a case where you get $1,000, attorney fees are $500,000, the attorney would have the option at that point of saying, I get the $500,000, you get your $1,000, or here's $501,000, I get my 25 to 45% of that, you get the rest. And I think that's what most lawyers generally do.
All right. So that's also on the table right here. If they win, then
the attorney fees in this case are going to be astronomical. And very often, let me just add one more thing in. Very often, something that comes into play, whether there's an award of attorney fees or not, is that possibility that there will be attorney fees. Because if there are attorney fees and they're huge, it's more exposure for the defendant and more of a reason for them to want to settle.
Right. Hey, by the way, is that true? Is that formula that you said true even for prison cases?
No. Let's not go into the PLRA. The prison litigation, okay, I'll just tell you very quickly because you brought it up. The Prison Litigation Reform Act caps attorney fees at 1.5 times the judgment. So if you get a $10,000 judgment, you're capped at a total $15,000 of attorney fees, and 25% of the judgment has to be applied towards your attorney fees. So if you get a $10,000 judgment and then you get $15,000 of attorney fees, really what you're adding on is it's $15,000 plus $7,500, because $2,500 from the $10,000 gets applied towards the attorney fees. It's one of the things that it's one of the many ways in which the PLRA stops lawyers from filing lawsuits, which I think was the goal of the PLRA.
All right, great. So now we spoke about attorney fees, how the attorney's going to get paid. Let's move on to the next count here. Count number 2, again, 42 USC 1983, supervisor liability. Now, so for this, it's got a little more complicated, but let's just pull up a case that I've got here. And everybody knows that I like to show the actual case law. So here's a case that talks about supervisory liability. And this is a First Circuit case, and they're in the First Circuit. So this is what the case starts off. Although a superior officer cannot be held vicariously liable under 42 U.S.C. Section 1983 on a respondeat superior theory, he may be found liable under Section 1983 on the basis of his own acts or omissions. So first, tell us, there's obviously a difference here between respondeat superior and supervisory liability under Section 1983. So first, tell us what respondeat superior is, and then we'll get into what supervisory liability is.
Okay, so respondeat superior, I know you know this. You're just letting me answer it because it's a softball. Respondeat superior, it basically means that the whoever's responsible is liable. Where you see this most frequently is in a negligence case. Let's say somebody is driving a truck for Kroger and they're negligent and they cause a crash. You can sue the driver, and vicariously you can also sue Kroger because they are respondeat superior. They are the boss, they are in charge, and they are in charge of the negligent actions of their employees and of the people who work for them.
Even though all they did was hire the driver. They had not that.
All they did was hire the driver, or potentially be the boss, the supervisor, the owner of the company, whatever it might be. Right. Supervisor liability is different than that. And it's also different than Monell liability. And this is where things get very tricky and complicated because a lot of the terminology is the same, but they're very different claims. Okay. Monell is when you sue either a supervisor in their official capacity or you sue an entity, such as a city or a county or a prosecutor's office or a police department.
How about town?
Monell is when you sue the entity. Supervisory liability is when you sue the supervisor. The elements are very similar. For example, if let's say there's a supervisor who actually knows that his or her subordinate is violating somebody's rights and they turn a blind eye to it or give it a wink and a smile stamp of approval. You got somebody who knows that one of his or her subordinates regularly beats people up after they arrest them or tases people after they're in custody. And this supervisor knows about it and doesn't do anything. And maybe even goes over to the subordinate and kind of laughs and smiles and says, "You tased him again, didn't you? You got it. After he was handcuffed, you got him again? Man, oh man, you and your taser." and then they keep doing it.
How about
Obviously,
how about like a thumbs up on some of the text messages? Okay, but yeah, so
thumbs up on some of the text messages. If it can't happen only afterwards. There has to be a causal connection between the supervisor's deliberate indifference to their subordinates' unconstitutional conduct and subsequent unconstitutional conduct for which that person is being sued. So if there's a supervisor and a subordinate that is aware that the subordinate regularly violates people's rights and doesn't do anything, you can sue that supervisor in his or her individual capacity, and they are still subject to punitive damages. Monell is where you say whichever people are in charge of this subordinate knew or should have known that this was going on, and they were deliberately indifferent, and that establishes a de facto policy, procedure, protocol, or custom under that entity, under that city or county or prosecutor's office or police department. Then that entity can be held liable for the unconstitutional conduct and the civil rights violation, but punitive damages are not available in a Monell case. Another big distinction.
Solomon, let me just stop you for a second. So just to break this down,
a lot. I know.
yeah,
I've argued all this stuff 100 times. So
just to break this down for everybody. So you just said the difference between a Monell and supervisory liability claim. Let's just concentrate on supervisory liability for the moment. That you're saying that there is punitive damages available. That you're saying that there has to be that the supervisor, whoever that was in this case, Tully Buchanan, was deliberately indifferent, which is a high standard, isn't it?
Yeah, it is. And
like willful blindness.
Willful blindness. And look, different circuits have different case laws. Some of it is reckless or callous indifference. Some of it is deliberate indifference. In the Sixth Circuit, where I practice most, which includes Michigan, is at least implicitly authorizes, approves, or acquiesces in the unconstitutional conduct of a subordinate. It's gonna be different based on statute or based on circuit, based on jurisdiction. But yes, ultimately there can be supervisory liability if the supervisor is responsible for the unconstitutional violation happening.
So again, so in this specific case, if the allegations, again, if we take all the allegations as true, which, we don't have to get into, but if according to the complaint, if everything has happened there and Proctor was doing all this stuff and Buchanan was willfully blind to that, or Tully was, or, they knew about what's going on, but they were acting with willful blindness or deliberate indifference to Karen Reed's constitutional rights, then they would be liable under this supervisory liability. Now, just one more part about this, because I think we kind of spoke about it. So it's not just respondeat superior, which is you're just the employer, so you're automatically under the gun. There's obviously a little bit more, a lot more, but which could be present in this case. Number one is that they had to have known what's going on or be willfully blind. Number two is that they did that with deliberate indifference to Karen Reed. And number three is what you're talking about before. You touched on this before a minute, was the causation element. And this is where the last part comes in here, where it says here, deliberate indifference, however, is not the be-all and the end-all of a Section 1983 claim premised on supervisory liability. As we explained below, there is a causation element as well. To succeed on supervisory liability claim, a plaintiff not only must show deliberate indifference or its equivalent, but also must affirmatively connect the supervisor's conduct to the subordinate's violative act or omission. So that's the causal part, the causation element that also has to be proven in this case, that it connects the conduct, which in this case, again, if Proctor is doing all these things right under their noses and they're being deliberate indifferent to it, and that's encouraging him to continue doing these type of things. And so would that satisfy this element, the causation element?
We'll see how the court rules, but it certainly seems like it could satisfy that element. And also something very important to remember is that circumstantial evidence is sufficient to establish this. As long as there's circumstantial evidence upon which a jury can reasonably rely in making such a finding, that's enough. It's very rare that you're going to have a supervisor explicitly acknowledge the unconstitutional conduct of a subordinate and give the thumbs up. But circumstantial evidence will often exist, such as turning a blind eye, a thumbs up in a text message, a laugh, a smile, different emojis, things like that. And by the way, these text messages are super, super rare in cases like this because the police are usually smarter than this, and they usually restrict these conversations to their personal devices if they're doing things improperly, and then nobody sees them. Because it's very difficult to subpoena or demand the production of a personal device.
Yeah, well, they got this because of the federal investigation.
They got it this right from the federal investigation. But without that, without the federal investigation, there's a very strong likelihood that Karen would have been convicted, and that this case, all the evidence that came out of possible wrongdoing would not have come out, not nearly as strongly as it did.
Yeah, 100%. Okay, so we've got the supervisory liability claim. Now let's move on to the next claim here, the next count. And we have conspiracy to deprive Ms. Reed of her Fourth Amendment rights. And here, not just Proctor, Buchanan, and Tully, but they also threw in the Alberts, McCabe's, and Higgins. Now, hold on a second. Didn't you just explain to everybody before about what the color of law means? And here, we're on 42 USC 1983, which would seem to suggest that you'd have to be that they're acting on the color of state law. Well, last time I checked, Jennifer McCabe didn't put on a police uniform to do any of this stuff, and neither did Matthew McCabe or Brian Albert or Brian Higgins, and for that matter. So why don't you tell us how can you even actually have this count of conspiracy when you're filing under this 42 USC 1983?
So this is also something that you and I have talked about in the past, and I actually suggested in a previous video that you had that this exact claim be filed against these exact defendants, or at least some of these defendants. The only way to sue a non-state actor for a 1983 claim that I know of is through conspiracy. 1983 conspiracy basically says that a state actor conspired with somebody, which could include a non-state actor, to violate somebody's rights and to deprive them of that right. Even though, and I'm not going to say, in this particular case who it was, but let's just talk from 30,000 feet more generally speaking. If a non-state actor conspires with a state actor to deprive somebody's rights under color of state law, then that non-state actor knows that he or she is working with the state, meaning with the state actor, to deprive that person under color of state law of his or her constitutional rights. And therefore, with that collusion, that coordination, that conspiracy, you can actually hold a non-state actor liable under 42 USC 1983. It's exceptionally rare, and it's an exceptionally interesting part of the law. And in this case, again, based on the allegations that were made and based on the evidence that's out there, I think the plaintiff has a very strong claim here against these defendants.
Okay, and we are coming near the end. So if you guys do have any questions, you can start putting them in the chat. But let's get through the complaint, and here we go. So let's get to the next count here. Massachusetts Civil Rights Act, the MCRA, and here it also includes the Alberts, McCabe's, and Higgins, not just Buchanan and Proctor and Tully. So this is the MCRA. So what would a Massachusetts Civil Rights Act? So is this kind of Section 1983? Is this, well, what exactly is this?
I'm not an expert on Massachusetts state law, but very often states will have language that mirrors a variety of federal statutes and constitutional rights. Very often states have their own constitutions, their own constitutional rights, and somebody who had their state rights violated can file a claim under that state law statute, whatever it might be. Obviously, there's a statute in Massachusetts called the Massachusetts Civil Rights Act, and it certainly seems to apply here. Again, I'm not an expert on Massachusetts civil rights law, but that's what that would be. It would be a Massachusetts civil rights law, which most likely mirrors a lot of the language in the federal law. But again, you want to file all of them, and you want to include all of them because you want to have as many claims as possible go to a jury.
Okay, so basically, yeah, this is just the state version of 42 USC 1983. That's what it seems like. And again,
that's a fair way to say it, usually. Yes.
Okay. So it's a state variety. Okay, now we have common law malicious prosecution. Is this kind of the same idea that you were talking about? This is the state version of malicious prosecution.
Right. So the state version of malicious prosecution is different than Fourth Amendment malicious prosecution. The elements are very similar, except that there does not have to be color of state law. So, for example, let's say somebody calls the police and says that Joe just punched him in the face. Okay. And the police come and they arrest Joe. And then the defendant in the case produces video footage proving that he did not punch Joe in the face. Wait a second. Did I just switch the victim and the defendant? I think I did. Right. Joe got arrested.
See if everyone's paying attention.
Yeah. So Joe gets arrested for punching somebody in the face because the so-called victim tells the police that Joe punched him in the face. Then Joe comes with video proving that he was nowhere near this guy, never touched him, and had nothing to do with it. If the police at that point continue to prosecute him, even though they know there's no probable cause that he committed the crime, they could be exposing themselves to liability. However, if they dismiss the charge at that point, the police cannot be sued for Fourth Amendment malicious prosecution. However, Joe could sue the guy who lied about him because when he lied to the police and said that Joe assaulted him, he knows or should know that Joe is going to get prosecuted. So he initiated this prosecution for a reason other than bringing the defendant to justice. And if it's done maliciously and intentionally, then the person can be sued. That's under common law. That has nothing to do with the Fourth Amendment and has nothing to do with 42 U.S.C. 1983. Again, the elements are very similar, maybe even identical, but it's a completely different statute and different defenses will apply. Qualified immunity does not apply, generally speaking, to state law claims. There could be other immunities that do, but there's a number of different ways that it differs. So that's why, again, you want to have both claims.
And one thing that you see very clearly right here is that for malicious prosecution, they named under the common law the Alberts, McCabe's, and Higgins, as you were saying.
Right. Because over here, it doesn't matter if you're a state actor or not.
Right, exactly. That's what your point was. Okay. So again, so that was the state version of the malicious prosecution. And then you have intentional infliction of emotional distress. Now, coincidentally, Karen Read is being sued by the O'Keefe family for this exact tort. They're suing her for intentional infliction of emotional distress. And now she's suing Proctor, Buchanan, Tully, Alberts, McCabe, and Higgins for this whole conspiracy. So I know my channel knows somewhat about intentional infliction of emotional distress, but just walk us through what this means in terms of Karen Read filing the lawsuit against, filing for this claim against these defendants.
I generally don't like this claim. I think that you get there without this claim. I like to have my federal claims, and then I like to have any other claims that are easier to prove. I think a state law claim very often is easier to prove, but in this particular case, I think that intentional infliction of emotional distress is more difficult to prove because what you have to get with intentional infliction of emotional distress, IED, if you will, is you have to have the intentional conduct or reckless conduct, but it's usually intentional. It's in the word. And the conduct has to be extreme and outrageous that exceeds all bounds of decency. I'm sure different states have different applications and different verbiage, but generally speaking, that's what it is. Extreme and outrageous conduct that exceeds all bounds of decency. Now, does lying about somebody so that they get prosecuted for a murder that the person didn't commit exceed all bounds of decency? Absolutely. Is it extreme and outrageous conduct? Absolutely, if proven. Causation, and then the last thing is the emotional distress. You actually have to prove severe emotional distress. Again, this varies by state, but there are some states that require you to actually allege and prove actual specific diagnoses for emotional distress. Why would you want to add this in unnecessarily? Now, most likely, it's not going to be that difficult to prove. You're dealing with somebody who, like I said, I don't think there's any evidence that she committed any crimes here, other than drunk driving, perhaps. Certainly, there's no evidence, in my opinion, that she committed a murder, and yet her life was completely flipped upside down for 3.5 years, where every single day she woke up thinking she may die in prison for a crime she didn't commit. That certainly creates emotional distress. However, and again, this is why you would need a state law practitioner, and why when I do cases like this, I virtually always work with a local counsel who knows the local laws. But you want to look up the actual state law and see what has to be proven before you plead a state law claim, such as intentional infliction of emotional distress. Because if it requires a specific diagnosis of emotional distress, you got to plead that. If it doesn't, you got to know that you don't have to plead that. But either way, again, from 30,000 feet, unless the specific facts require it, I don't like intentional infliction of emotional distress claims because there's that added element that you have to prove. So why do that to yourself? I mean, frankly, this case is not going to be won or lost on this claim. I think that kind of jumping the gun here again. If the defendants here were smart and reasonable, they would want to settle this case very quickly. This is a case that can spiral out of control. I don't think this is a case that can be won by the defense based on the evidence that I've seen. I don't know how they possibly excuse some of the things that they did and said in this case. And I said this, I think I said this over a year ago. I think Karen Reed is about to become an exceptionally wealthy woman.
Okay, well, it may take some time, for this litigation to get
It very well take a lot of time, but that's what I think is the inevitable result here. And I think I said that probably about a year ago.
Yeah. All right, let's move on. This is the civil conspiracy. So is this also kind of like the state variety of the conspiracy under 42 USC 1983?
So yes, except that 42 USC 1983 civil conspiracy is that you conspire to violate somebody's rights, somebody's constitutional rights. Civil conspiracy is just that you conspire to do something wrong to somebody, whatever it might be. So, and obviously you're scrolling through it right now. There's a lot of different things that they're alleging here that could have been the wrong that was done here. But when two people conspire to do something wrong to somebody, that's civil conspiracy.
All right. Well, that is the complaint. Those are all the counts of the complaint. Now, is there anything that you noticed that's not there?
Yes, there is something that I noticed that's not there, and that is a Monell claim. I did not see any Monell claim here against the police, which there could be a reason for. Okay, there definitely could be a reason for that. And I'll tell you, I don't know Massachusetts. I know that, for example, in Baltimore, the Baltimore Police Department is considered a state agency. So there are some police departments, even though they're not state agencies, that are considered state agencies for purposes of 1983. I don't know if that's the case here. I doubt it is. It's usually not the case with the city police department. But what I think was particularly interesting here is that the city or the police department, they were not sued under a Monell claim. Monell is when you sue the actual corporate entity, such as a police department or a city or a county or a jail or some other municipal entity. And the allegation is very similar to supervisory liability, that there's a either explicit or implicit, de facto or real policy, procedure, protocol, or custom to violate somebody's rights. And that can be established through lack of training. That can be established through lack of supervision. There's a number of ways that can be established. And I think if ever there was a case where there could be a strong Monell claim, this could be it. Now, there's a number of reasons to include a Monell claim. There are also a number of very good reasons not to include a Monell claim. The overwhelming majority of Monell claims get dismissed by the court eventually. So there are some lawyers who say, you know what, let's not file it. I think the strongest reason to include a Monell claim, first of all, is because I think in this case, you've got the elements met. You certainly have a good faith basis to allege that the decision makers responsible for these corporate entities allowed this de facto policy of violating Ms. Reed's rights. However, like I said, it's very difficult to prove. The reason that I think you might want to add a Monell claim for a case like this is for discovery purposes. Let me explain what I mean by that. If you send out a discovery request to a defendant in a case, they have to search their records and see if they have any responsive documents. If it's not a party, they can charge you an arm and a leg for those records. So for example, let's say they send a subpoena to the police department or to the prosecutor's office. The prosecutor's office or the police department could charge you a whole bunch of money to dig into the records. They can file a motion to quash. They can do all kinds of things to prevent your discovery from being turned over and from being disclosed. And when they're a party, they can't make those same arguments. So when they're a defendant, you can just send a request, a discovery request to the city. And then the city has these documents available to it. The individuals may not, especially if the individuals no longer work there. Let's say you sue a former police officer and you say, give me all emails, records, and correspondence that you had with the city attorney. I don't have any of that. I didn't keep any of that when I no longer worked as a police officer. But if you send it to the city does. So that's one good reason to keep them in. Now, another glaring thing that's missing is that the prosecutor's office is not named. And again, there's a number of reasons to do this. It's very difficult to sue a prosecutor's office. You can't sue individual prosecutors. Let me say that again. If a prosecutor conspires with a law enforcement officer to commit perjury and put an innocent man in prison, you still cannot sue the prosecutor. Prosecutors have very, very strong prosecutorial immunity. It makes me sick sometimes, but they have that very, very strong immunity. The defense of this immunity is, well, prosecutors have to be able to be free to prosecute cases. And I agree 100%. So there should be a heightened burden of proof. What if you improve intent? If you can, what if not recklessly, not callously indifferent, what if the proof is actually intent? If you can prove that a prosecutor intended to violate somebody's rights, what if you find a smoking gun email between a prosecutor and a witness saying, I know that this defendant is completely innocent and I know that he didn't do anything wrong, but I think I can get him to, I think I can get him 20 years in prison. And frankly, I don't like the shirt he's been wearing. So let's nail this bastard. And then they go and they get the guy convicted and he goes to prison for 20 years. Then this email comes out and they get the conviction thrown out. You can't sue that prosecutor, which is outrageous and it's ridiculous. You can, in very limited circumstances, sue a prosecutor's office for a Monell claim. There you have to prove that the decision makers and policymakers of the prosecutor's office had a de facto, implicit, or explicit policy, procedure, protocol, or custom that led to the violation of the rights in this case. And again, if ever there was a case where such a thing existed, I think this is the one. This prosecutor was getting up and making all kinds of statements that I told you at the time he should not be making. I think it was a big mistake. And I think it exposed that office to potential liability. Now, that said, there could be reasons not to include them in this lawsuit. For all we know, they're already working on a settlement. Maybe they're working on some sort of other resolution with the prosecutor's office. Who knows? There could be reasons not to include them. But that's something that was just glaring when I looked at it. And just one last thing that I don't know if any of your viewers noticed this or not, but you'll notice that when every individual is named in this lawsuit, if you want to pull it up, I can actually show you. If you go to page 8, where it discusses the parties, paragraph 17, page 8, you'll see that the police officer defendants always says sued in his personal capacity. 18, personal capacity. 19, personal capacity. 20, personal capacity, right? And then the other ones are just individuals residing. The reason that you do personal capacity is that when you do a 1983 case, if you want to sue them and get punitive damages and be able to go after them for their violation, it has to be an individual capacity or personal capacity lawsuit. If you name them in there what's called official capacity, that is the same thing as making a Monell claim. So very often in a case like this, what I'll do is I'll say the officer is being named in his individual and official capacity, and then I'll also name the city in a Monell claim. But obviously the lawyers in this case made a determination not to include a Monell claim here. I'm curious why. I'd really love to know why. There's plenty of good reasons to do it both ways. It's just, I think it would be a very interesting conversation to have. And if you're ever fortunate enough to talk to the attorneys or to Alan Jackson, that's definitely a question that I'd want to ask. Number one, why did you sue the prosecutor's office for a Monell claim? And number two, why didn't you sue the city and the police department for a Monell claim?
Yeah, okay. Well, that's, I think that's a good point about Monell, because I think it opens up, like you said, the floodgates of discovery a lot. And I've seen you done this on civil rights cases where you're able to get a lot more discovery, a lot less barriers when they're a party to the lawsuits. So even if you don't feel that you're going to find, legitimate at the end of your basis for your claims, they'll get dismissed. But during the process, you'll get all these documents, and it'll be a lot easier to prosecute the other claims. I think that's a great question for the Reed defense team. I know that you're going to love when I bring this up. I know that. And I know that after discussing this case with you, we cannot let a show go without bringing up this topic. And you know exactly what topic I'm talking about. I'm talking about the topic of qualified immunity. So I don't want to ruin your day now.
Qualified immunity has outlived its
as it relates to this case.
Okay, so first, from 30,000 feet. qualified immunity is almost never explained properly on YouTube or in the media. You've got people who either don't know what it is or intentionally misrepresent what it is. You cannot sue a police officer for doing their job. And that's not what qualified immunity protects. There are two prongs in qualified immunity. There's two different things that are included in qualified immunity. Number one is called clearly established. Number two is called any reasonable officer. The way this works is the any reasonable officer standard, I think, is absurd. What it means is you look at a case and you ask yourself, not what did this officer know or should have known, not what did this officer observe. You ask yourself, this is based on the qualified immunity test, what did this officer know and observe, and what would any reasonable officer in his shoes do as a result? Okay, I had a case, just to magnify how absurd this sometimes gets. I had a case where I got an officer to admit during his deposition that he knew that what he did was wrong. The judge said, even though he acknowledged that what he did was wrong, any reasonable officer in his shoes may have disagreed. So even though this officer knew that it was wrong, he's still entitled to qualified immunity because any reasonable officer, maybe there's some reasonable officer out there somewhere in the world who would have thought that this was okay to do. And therefore, the case goes away. Okay, so that's number one. The any reasonable officer prong, I think, is insane. The second prong, I think, is even more insane, and that's the clearly established test. And after we get done with this, by the way, I'm going to share one interesting fact with you that I think really proves beyond any question how ridiculous qualified immunity is. Okay.
Okay. Before you just go on, I'm going to let you finish in a minute. We're coming up to the time, but if you do have any questions, start putting them in the chat now. I see that there are 3 that I have to get to, but if you have any more, put them on. And as soon as Salman has to go, he'll go. But I'll try to get that as soon as I can. Okay, go ahead.
The clearly established test basically means that there has to be a case that is binding in this jurisdiction with virtually identical facts before you can sue the police officer for it. In other words, if let's say you got a cop who tases somebody and you say that tasing somebody is unconstitutional because it's excessive force, right? Let's say somebody's compliant. Turn around. They turn around. Put your hands up. They put their hands up. And then the cop tases them anyway, or beats him with a baton, or shoots him in the back. In order for you to be able to sue the police for any of those actions, you have to be able to show that there's another case in this jurisdiction, binding case law, where a police officer did the same thing in the same circumstances and it was found to be unconstitutional. If a police officer tases somebody, but the only case law that exists in your circuit is about shooting somebody, he'll get qualified immunity. And the case will be thrown out, even though he knows that this is excessive force, and even though he knows he's violating this person's rights, because it's not clearly established. Anybody who doesn't realize and understand how absolutely absurd qualified immunity is, just do some Google research on this, on what exactly clearly established means. And you'll see that it's not protecting police officers who do their jobs. It's protecting police officers who intentionally violate people's rights. Last point on qualified immunity. The biggest proof that it's a crock of baloney and that it's intellectual dishonesty is that you have to understand qualified immunity was created by the courts. It's not in the statute at all. It was created by the courts. And it was only created in a civil case. What does that mean? Let's say you got a police officer who shoots at somebody in the face, okay? And that person sues the police officer for excessive force. And that city's prosecuting attorney prosecutes that police officer for attempted murder. The police officer can only use the defense of qualified immunity in the civil case, not in the criminal case. So this whole pretext that we need qualified immunity to protect police officers so that they can do their jobs obviously is intellectual dishonesty, or it would apply in a criminal case. Do you know why it really exists? Not to protect the police officers, but to protect the government's pocketbook. That's why qualified immunity exists. And that's why it only exists for the same exact action. It only exists in the civil context, not in the criminal context. It is outrageous. Qualified immunity, maybe it was created by the courts with the best intention. It has outlived its usefulness. It is used as a sword instead of a shield. And frankly, it has been expanded to the point of absurdity.
Yeah. Okay. Well, now that you've given us that on qualified immunity, not that I haven't heard that speech before.
I know you have.
But, I mean, I think you say it very well. But the question is, okay, so now let's talk about this case. So you got this case where you got Proctor doing what he's doing. You've got these allegations of tampering with evidence and things like that. Qualified immunity, what you're telling me is, number one, would a reasonable police officer feel that he can tamper with evidence and plant, taillight or whatever? Let's just say that that's proven, right?
Right.
So that's number one question. They're going to have to say, okay, well, maybe a reasonable police officer would feel that they can plant, but that I would think is not going to be applicable. Am I right?
They're going to argue it. They're going to argue it because
argue.
you never know what the court's going to do. I've seen courts make very questionable rulings when it comes to qualified immunity.
But let's go to the second prong, because the second prong was really what more concerns me. The first one, I would imagine that if they're able to show with enough evidence that there was some tampering with evidence, there was some hiding evidence, no reasonable police officer would think that they can do that. Number two is like the second part that you said about having notice. What was it? What was the exact terminology?
Clearly established?
Clearly established. So if there is no case in the First Circuit or Massachusetts State common case law where you have a police officer who tampered with evidence, then is that also a possible way for them to get qualified immunity in this case?
Yeah, absolutely.
I think that's exactly what you're
100%.
saying.
If it's not clearly established, then you can go to the court and say, Your Honor, how is my client supposed to know that he's on notice that this is against the law, that he's not allowed to tamper with evidence?
And plant evidence.
Yes, that's exactly what will likely be argued. And I'm telling you, when the 12b6 motions come in and you read it and your head starts to spin, we can do another show then and talk about this.
Yeah. All right. Well, that's going to be coming. Let me get to some of the questions here before you go. Let me see what it says here. Ellen Fagerlund, like you've said, Martin, trying to tie the two together always goes to okay. We try to keep this show. Mathis Grias. If Karen Reed is sued 2 times and jurors find she hit John O'Keefe, doesn't it trivially follow that she defamed the accused third parties and vice versa?
Very interesting question.
So if there is a jury that comes out, let's say in the wrongful deaths case, let's just talk about that case, right? Let's say the jury finds her liable for damages. So does that automatically mean that she defamed? And I would say no. That's what my position would be.
Not that she defamed, not necessarily that she defamed, but will that probably destroy her lawsuit? Could very well be.
Right, but in terms of the defamation, I think that she would still have a claim that she was still acting in good faith, that she thought that these things were true. Maybe it was proven otherwise, or maybe the jury disagreed with her, but I'm not sure if I would go there. Here's a question. This is a super sticker. Thank you very much for that, KHM. And here is from our good friend Drop Microdots. Solomon, what do you think the feds are doing? How can they allow this? Great show, brother Counsel. Well, I got to say, it's always a great show when I can just sit back here, ask the questions, and let Solomon do the work. When I have to actually do the work, then it's a harder show. People like Solomon talking more than me, apparently. But it's always easier for me to have Solomon on. So go ahead.
I've worked on a number of federal cases, and what I can tell you is this. We have no clue what the feds are doing. We don't know if they're about to indict a bunch of folks. We don't know if they're done with their investigation. I can tell you this. The feds very often work very slowly and very deliberately. And once they get somebody where they want them, they just let them dig deeper. Can you imagine if, let's say, the feds do plan on indicting some of these folks, and if they would have indicted them before the trial or in the middle of the trial, before they had a chance to testify, there would be much less evidence. Now, and I don't want to go through each witness unless you want to, there were plenty of police officers' testimony that could very seriously hurt police officer defendants in a criminal prosecution if the feds choose to go that way. So it could be with all these new lawsuits coming out now, maybe there's going to be affidavits attached. Maybe there's going to be more testimony. As long as they don't have a statute of limitations problem, there's no reason for them to hurry this up. They could just sit back and watch. Now, it's entirely possible that they're done and that they're not going to indict. It's possible. We'll see. There's no way of knowing. Anybody who says that they've got, inside information from the FBI or from the DOJ, I don't know. I would very seriously question the validity of what they're saying. But I guess we'll see. We'll see soon enough, and it will certainly be interesting if they do go that route.
Basically, you know what the feds are doing once everybody knows.
Right.
That's how it works. Okay. All right. Well, thank you, Solomon, again for joining us and giving us your take on all this. All this civil rights talk is very important and educated us all on this lawsuit. And, look, I mean, there's been a lot of requests for you to come on more often. So you're just going to have to take a little bit of a step back from all of your civil rights practice and then get more with Brother Counsel on my channel. I got to say that, I know that Nick Rocco talked about that he has exclusive access to the Karen Reed defense team, but guess what? I have exclusive access to Solomon Radner. I'm not sure which one, people would rather, I'm just saying. I got exclusive access to Solomon. So if you come on more often, that would be a lot of fun. And I think a lot of people would enjoy it. So,
well, I will say this. I always enjoy spending time with you. I think that Brother Counsel is the best YouTube channel out there. I think that Brother Counsel is the best legal channel out there. And I love being on as a guest. I love working with you on cases. And anybody who wants to follow me, I'm on Twitter these days, or X as it's called, at Solomon Radner, SOLOMONRADNER, at Solomon Radner. I occasionally tweet, not nearly as much as some other people do, but when I find something interesting, I sometimes share it. So if you want to hear more of my legal thoughts, obviously feel free to follow me there. And otherwise, Martin, I'll see you next time.
All right. Thank you so much, Solomon. All right. Well, that was it. That was the Solomon. That was Brother Counsel's Brother Counsel. We got a little bit of an idea about all these counts and what they mean. There may be another show that will actually go through and walk through the entire complaint and break it down piece by piece. It's a longer complaint, but I really wanted to get this out of the way so they can really understand the charges that are being brought. The different. This is all civil rights stuff. This is right. This is what Solomon does all day. I mean, he eats this for breakfast, lunch, and dinner. Although he doesn't eat that much during the day. But that's the idea. So that's why I think as this case progresses, I would love to have Solomon on more and more. Definitely when the motions are being filed in this case, 12B6 motions, as you spoke about, motions to dismiss. Probably hear a lot about qualified immunity and all that good stuff. And I'd love to have him on more often. Otherwise, you're just going to be stuck with me. You'll be stuck with me, little old me. And, you'll have to deal with me by myself. I mean, this is going to be very interesting to watch. We're going to watch the consolidation. And again, this is just me thinking on my own. I would imagine that the Karen Reed team wants to stay in state court. And if they consolidate this, I don't know why they need to consolidate, but if they're going to consolidate it, then there's a possibility, there's a real possibility that will get removed to federal court. The entire case. If it gets removed to federal court, we're not going to see a lot. We're not going to see as much as we get to see. We saw oral argument, saw the filings in the state case. We're not going to see if it's in federal court. So I mean, again, I don't know. I think it would be advantageous for the Reed team to stay in state court and not get removed to federal court, and may as well at least have her defending against this case, the wrongful death case, in state court, because that is in state court. That wasn't filed. So that wasn't filed in federal court. So, but if they consolidate it, then everything can be removed. The entire case, everything. And then we're not going to be able to see it. We're not going to see the trial. So I think that would benefit all the defendants here. Here's another question here. Commonwealth was allowed by Allison was allowed to fresh theory in which Karen couldn't bring up the failed number one theory. McCabe tweaked, and hedged qualified testimony to Taylor fit 2025. 54%, she is definitely in the zone. So I'm not following this 100%. But yes, she just needs to be shown to be 51% at fault. It's only a preponderance of the evidence. So if that's what you're saying, that there's more of a chance, that there is more of a chance, I'm not following the entire question. I apologize. But yeah, it'll be interesting. Okay. All right. Anyway, thank you everybody for joining today. Thank you for coming out and seeing Solomon. Always great to have him on the show. And we'll see you all guys the next video. Take care, everybody. And also, before you leave, before I end the stream, don't forget to subscribe. Don't forget to like. We got to help the channel build a little bit. Really helps the algorithm. So it doesn't cost anything. It's free. So just hit the subscribe button, hit the like button. And thank you all for joining us. We'll see you next time.